Listen, friends, if the Lord is making you wait, then wait. Trust me, he's trying to show you something. Maybe he's trying to show you that you're not ready for what you're asking for.
How about this? How about you just stop playing in my face?
Olivia, what's going on? If I don't see you in the classroom right now, you're going to get in big trouble, okay? I'll be there in a second. I'm running late.
Nobody takes fucking pride in anything that they do, and I get it.
Because bitches be mad at other bitches that be looking pretty.
What's possible? Well, it's possible.
Baby, let me tell you something. When this money breaks down...
Garage.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
Garage.
Oh, he's got Riz Plus.
Between screeching into this microphone, between making Cameo videos, I bet you I don't make $20 an hour.
That's not my job. So...
Guess what, hun? Your sister didn't answer the phone.
I'm a ditzy girl because I'm a fucking giggler. Oh, let me giggle. And the other guy, tell him to get the out of his mouth.
I don't give a.
They can't put ketchup in the bag, and I'm rude for asking for ketchup?
Reasonable if the hair came from him, correct?
Peg leg ass. I don't do peg leg ass.
Why are you in a chat room with James's baseball team?
Because I'm doing my cape.
Correction, I teach at George Mason University, not Georgetown. That's correct. It is closed source.
Can I get some ketchup?
Oh my God, what is that? Oh my God, what is that?
My God, what more do you want me to do? Do you want to for ketchup? You want me to throw neck for ketchup?
Absolutely, yes. That's an open source tool, but thank you. I
just came back from the dead and they told me, you still not that girl.
Welcome. I know I'm spoiling you guys. We had class this morning and a special guest tonight. So without further ado, I know we got a lot of questions. We got a lot of askings, okay? We're going to be discussing the Turtleboy hearing from the 7th earlier, a couple days ago. I know he already explained it, but I still got, questions. I still got stuff that I don't know that he's talking about that. Guys, what do you want from me? Okay, I'm new to the law stuff. I'm new to all this stuff. So he's patient. I like the way he explains it. So stop. Don't fretero. No need to get upsetero. Whether you're laying in your bedero or fixing a plate of spaghettero, making sure your kids are federo, walking your Irish setero in a brand new pair of keteros. Don't forget to take your Metaros. Open your ears on your hetero. Listen to what is setero. Like and subscribe. Don't forget-ero. Put your hands together-o and help me welcome
Mr. Bederow.
Welcome.
How are you?
Good. How are you?
I'm okay. What's up? You're silent.
I'm back.
You're back. Yeah,
wait, did you not hear the poem?
I heard the introductory poem. I didn't hear what you said for the last 10 seconds.
Okay. It says, welcome. Thank you. And this is last minute. I got questions about the hearing that I was at. I know you discussed it, but I need it like kind of breaking down just a couple things that I'm like, let me make sure that I know this is correct. But first things first, I know we got to get this out of the way because I got 1,000 messages about it. The Jackson Lettero.
Yeah.
What does it mean?
Well, it's kind of funny because it's a letter, and I was told real lawyers don't write letters; they do other stuff. It means they want Kelly Dever on the so-called Brady list and are laying out the reasons why the Boston police are required to submit her for inclusion because, according to them, and it's very credible, makes perfect sense, she either perjured herself by saying she didn't remember what she told the FBI, which I think seems like a very high likelihood, and clearly the witness were to perjure themselves, that would be problematic to their credibility. Or alternatively, if she didn't, she has this terrible condition, false memory syndrome, or whatever it is, which, I mean, if that were true, and I would suggest it's kind of ridiculous in these circumstances, but if that were true, then her credibility is substantially impacted in an adverse way as well. I mean, because, she's got to testify in another case and people are going to say, don't you suffer from false memory condition, right? It happened to you in the Cameron Reed case. So she's kind of screwed either way. And I think that this is just the next shot across the bow from, Team Reed. And I'm sure there'll be many, many more. And, they're coming from a position of strength now where maybe they weren't a few weeks ago. I mean, she was still fighting for her life. Well, now she's won and, they want to take names and I'm assuming file some lawsuits, and this is all part and parcel of that, I would imagine.
Okay. Let me ask one more question about that, actually. Remember how she said on the stand, she was like, well, I realized after talking to the Bederows that I'm not sure what was my memory and what was media provided. Remember when she said that about the Sally Port camera in the garage? So she's saying she doesn't know what's her memory and what she saw of the Sally Port camera, correct? That's basically what she's saying.
Yeah, she's being clever. I mean, she's clearly was counseled on how to do this in a way where people would lead her to believe that she's not committing perjury either in the state court trial, but also not exposing herself for lying on a material matter to the feds, which is a crime. That's the so-called Martha Stewart crime that everybody remembers if you're from a certain age, where Martha Stewart went to jail, not for stock fraud, but because she, made a false statement to the FBI about what she was doing. That's 18 USC 1001 is the famous statute. And if you don't intentionally mislead, which is what she was saying, I was confused and then it might have conflated with a memory, she's tap dancing through the minefield. I'm not lying today. I didn't lie to the FBI either. I was just confused. I had a false memory. I might have seen something later. Either way, I don't want to cooperate with the defense. I'm not here to help them, but I'm not lying. I mean, it's too clever by half. And then her terrible demeanor on top of that really made her look just ridiculous.
So when she said things like phrases like "in good faith," that's like a trained kind of thing to say, right? Okay.
Yeah, no, she's making it clear I did not lie in her mind. I mean, she twisted herself into a logical pretzel, but she's basically saying I did not lie to the FBI. I am not lying to the jury today. I'm always been consistent in telling the truth, but whatever I told the FBI, I was under the mistaken impression of, something I actually did not see. But at the time I said it, I thought I did, but I've now learned that it was a false memory. I mean, this is really, really ridiculous stuff that was coming out of her mouth.
And also when she's like, I'm not sure what's mine or what's media provided, that was when she talked to the feds before the first trial, which the video of the Sally Port wasn't out at that point.
I mean, she spoke to the feds around the time when everyone else did, which was what, in my recollection is
August,
spring or summer of 23 or whenever it was.
Yeah.
I don't know what exactly she would have seen or not seen, but the reality is she told the FBI that I saw them in the Sally Port the day of this incident. I was watching through the camera, like the dispatch room cameras. I knew it was Higgins. I knew it was Berkowitz. I thought it was very weird because Higgins was a witness and they're hanging out with the car in that case. And they were there for a long time. I mean, there were a lot of details for somebody who claims it was just a false memory, which is not something you would usually see. I mean, that kind of detail suggests at the time she spoke to the FBI, she told them the truth. And then, of course, she later left the Canton police altogether, which is interesting. She ends up in John O'Keefe's department, which is also interesting. And then what happens? She finds out she's going to be a defense witness. And all of a sudden, she has false memories and comes guns ablazing with that kind of attitude, very angry, very unprofessional. And, you know, the reality is her career is over. I mean, she chose poorly. You know, she could have handled this any number of ways, and she went the double bad way. You know, she went with the kind of bullshit story, and at the same time, she just poured on the attitude to just come off like an impetuous child on top of anything else. But any way you look at it, I mean, is that the kind of person you want with a gun and a badge on the street, confronting, you know, dangerous people and split-second decision-making street encounters when you need to be patient, you need to be fair, you need to be alert, you need to be many things. And she, unfortunately, doesn't exhibit any of those, and just pretty much ruined her career with this spectacle of a few weeks ago.
Took her 16 seconds to answer yes or no to remembering whether or not there was a camera. Like, that's a long time.
That's not 16 seconds to remember. That's 16 seconds to take inventory of her life. Which way am I going? Am I going, you know, am I taking the red pill or the blue pill kind of thing? And I mean, on some level, I almost feel bad for her. I said almost bad for her, because I think that delay, that wasn't trying to remember what happened. That was, am I really going to do this? Am I really going to do this? And she did it. And, you know, she got burned bad.
I know, you do kind of feel like a little bit bad for her. Like, you do. I feel like you, like, as much as we can like shit all over her, it's like it's like, it's not her. She's not the problem.
Well, yes and no. I mean, look, she's a young police officer with an impossible thing. She's getting leaned on by the commissioner of a large department. She's a rookie. It's this case. You don't want to go against, you know, John O'Keefe was in their department. She's being told essentially what to do. And that's difficult. That's a lot of pressure. The blue wall is leaning on her. On the other hand, you still have to be an honest person to do what's right. And she came up with this ridiculous story. But even if she was going to give that story, not that it would be right to lie. I mean, that's not, perjury is perjury if that's what she did. But she did it with such an attitude where, imagine if her tone was, you know, it's a false memory. I just, you know, it was, I looked at this, I looked at that. I know that's what I told the FBI. It's what I thought at the time. But now that I recall, you know, it's not what happened. I mean, I'm not saying her story would be believable, but I don't know that she would be getting nearly the attention she's getting if she didn't just cop the all-time worst police attitude that you could imagine on the witness stand. I mean, I think that kind of is what people remember, is just how impetuous and childlike and petty she was.
What do you think would have happened if she said what she said to the Bederows on the stand?
Nothing would happen in the classic sense. She would have presumably told the truth. She would have provided the defense with pretty good evidence that would have been without having to pull teeth in the way that they did. And then the question would be, how is she treated by people in the Boston Police Department? That's the risk, is, you know, you've become the rat. You helped the killer, if you will, get away with killing our guy. I mean, I'm sure that's part of the calculus in her mind, is I already left the Canton Police. I went to the Boston Police. And what happens if I betray them, whether it's right or wrong? And again, that's the pressure of the blue wall. It is a hard decision, but you know, you have to do it the right way. And she chose the wrong way. She chose the wrong approach and attitude. And look at her now. You know, she's on family medical leave, which, you know, again, it's kind of sad. Google is forever. She's never going to get past this.
Right.
She's getting pummeled in that letter by Alan. I mean, it's a strong letter. It's fair. It's all true. I mean, she does have credibility problems that do require all defense attorneys on her cases to be given a Brady notification. I mean, you have to. I mean, she was a complete disaster. So, you know, she made her choice, and now she's got to live with it. It's just, it was all so avoidable, but you want to feel sorry for her. You do, but she's got a lot of blame in this too.
All right. Thank you for answering that. Enough Dior.
You're right.
let's get to your let's get to this week. So I go in, I sit down, I see you there doing your thing, right?
Right.
You gotta go TCOB.
Take care of business?
Yeah.
Right now?
Yeah, you.
No, I'm just peeking at the Red Sox losing. That's all. It's
all right. So I didn't know if something was going on.
No, I'm looking at it's fine. No, go ahead. I
didn't know if the missus were getting lippy and you had to go, listen. Hey, listen.
We don't do that stuff around here.
All right. So we sat down, right? And they tell you guys to stand up. They read the charges and they say offense 1 of witness and intimidation of a witness, offense 2 intimidation of a witness. Now I thought there was 5 charges.
On the new indictment, it's just 2 counts.
So okay.
Basically, the allegations are that Chris Albert and Colin Albert were intimidated by, what happened with the window at D&E and the internal camera. And apparently in viewing that from off site, the allegation is that caused them some kind of emotional harm, and that the prosecution believes that they will prove that whatever happened that night was done with the intent to impede justice, essentially because they were witnesses, in a case. It's probably not the right time and place to say anything more than that about the charge itself. This one is pretty ticky-tack, though. This is really, I don't think they look very credible in charging that case in particular. Sometimes, you think you have a colorable claim, but if you've seen the video that was on TV or you've seen it around, you see what the allegation is, you see what the evidence is, you see where they're coming from, you see what these people are doing, you see the kind of mood they're in, you see what they're saying. The idea that this was, an intent to impede justice by intimidating people because they were witnesses in a criminal case, I think is an example of just more overreach by out of control prosecutors and state police who have been exploiting and weaponizing this very flawed Massachusetts statute for a long time. And in particular, on anything that relates to Karen Reed, and in particular, anything that has a viewpoint that tends to favor Karen Reed. You've seen it with these ridiculous rubber ducky things and all of that. And really what's happened is just, the Massachusetts authorities are making a laughingstock of themselves. There are things I think all would agree that could constitute witness intimidation, but throwing ducks on the ground and, peering into windows and making faces and, T-Rex arms and giggling around and whatever. I think, at some point you have to be serious about what you're doing and find a better way.
Okay. So because there was, and if you can't answer this, I get it. I'm just not quite sure. Offense 1 and offense 2. Does that mean 2 different people? Like one's Chris, one's Colin?
Yeah, they're both allegedly intimidated, right?
Okay, so that's why it's 2 counts, correct? Okay. Next, the 5,000 plus pages, right? Protective order. Protective orders are, what are they, like state restraining orders?
So a protective order limits the disclosure, dissemination, and discussion of the substance of anything that's under a protective order. And in Massachusetts, they have a particular term that they use called impoundment. So these documents or information are impounded, which means they can't be submitted in a public filing without being redacted, or if they're discussed, the information has to be redacted. The problem is this. So trials and court proceedings are presumptively public. The public has generally speaking, a right to know what goes on in court. And that includes in the courtroom, because it's public, and what's included in the court file, because that is considered public as well. As a citizen, you have a right to inspect the public court file and look at I mean, you could pick any random case, eeny, meeny, miny, mo, and it's just some rando drug case out of some other town in Norfolk County, and you could say, I want to see the court file, and it will show you whatever it shows you. There are times where certain things are, I mean, where I come from, we use the word sealed. They're not available for public inspection or impounded in Massachusetts for good reasons. You know, sometimes if it has someone's identifying information or they're secretly cooperating in a case involving violence, you know, there's certain information that may not be public. It's understandable for the short term. The problem with what's happening in the cases that we're dealing with is the presumption has been entirely flipped on its head and is upside down. Over the course of several months, the materials that we have been getting in discovery, we've been getting by having to sign a protective order and agree that they're impounded. Now, these are things we are legally entitled to. Okay, so the reality is we're entitled to it. We don't have to agree to it, but if you don't agree to it, there could be litigation over it. There could be argument. And when you get discovery in a case, certainly cases like this, you want it right away. So what you've seen us do until this week is say, the hell with it. We'll agree to the protective order for now to get the discovery, and then we'll work backwards and try to unimpound it and get it available if we have to. But again, this is entirely upside down and backwards. So what happened this past week was they wanted to do that again, and we said, no, we're done with this.
The candy thing.
Because that's right. Because in order to impound it, you're supposed to have a basis for it. It can't just be the information is embarrassing to the government, right? It just can't be that, you know, if you're talking about the district attorney's emails and he would prefer that you not see them for whatever reason, or other people are sending emails and doing things, the fact that it would hurt and embarrass them and make them look foolish is not a reason. There can be reasons, but that's not one. You know, witness safety, again, privacy can be perhaps another reason. But when you have all these witnesses running around making statements on ABC News, NBC News, arguing their positions, they kind of lose that argument, which is something that we pointed out. I mean, it's one thing to say, you know, there's certain emails from Michael Proctor, text messages that ought to be sealed, impounded, whatever the word is, but because, you know, he's entitled to privacy and this and that. Well, the reality is he's made himself a public figure in this case. Everybody knows he's the fired state trooper. Everybody knows he's become the quintessential boogeyman for Karen Reed and corruption. And everybody knows that he went on a press tour and denied doing any wrongdoing and whatnot. So he has placed all of this in issue himself. So there's no legal basis for any of this to be impounded. There's no legal basis for all the old stuff to be impounded. And there's no legal basis for the stuff that we, you know, what you're calling the 5,000 pages, that which I'm laughing at, but that we just got for that to be impounded as well. Now, it is temporarily. The judge agreed to do it to give us the materials, but what he said was, we're going to address this quickly in a couple of weeks, right? So I would expect that almost all of these materials will become unimpounded for the simple reason there's no credible basis for them to be impounded in the first place. It just can't be because, you know, Turtleboy will embarrass us. You know, that's not a reason to impound documents. But the irony is the victim in this situation, if you will, the victim of the unlawful impounding, which would violate the First Amendment, is the public. The public has a right to the court file. Okay, the public is the one who's being deprived the information. If this were to be unlawfully impounded any further, the public could attempt to intervene. You've seen cases where media organizations challenge sealing of documents, impounding of documents, gag orders, this or that, or all kinds of things. And I think at some point you would see that if this continues to happen, but I don't think it will continue to happen. I think it'll be over soon.
Okay. That answered a couple questions, actually. So when they release it, right?
Mm-hmm.
Is that going to be a random day, or is that going to be like an August 13th situation? Like, is that like a random day the judge decides like, oh, it's all good?
It could be, but if my memory of what happened last week is correct, I think it's essentially August 13th. I think he gave the prosecutor time to put together any argument he wants to make. And at that point, the judge would rule. But the issue is this. If you need time to make an argument, to impound documents, and you don't have one ready, I would suggest that indicates the weakness of your position. Again, the presumption is it should not be impounded, and the prosecution should be the one asking for certain items to be impounded for these reasons. And what's been happening in this case is no reasons are being given. They're just saying, we're going to put it under a protective order, and then we'll give it over. And it's just, as I kept saying, it's upside down. It's just a complete opposite of how public court proceedings are supposed to occur.
So that's why he asked for the 2 weeks when he was like, what, I'll give you a week. And he was like, can I have 2?
Yes.
Which I'm like, why are you trying to buy weeks, sweetie? I don't know if you're going to be here in 2 weeks, brother. Like, sorry, I don't mean to tell you, but love him. But like, I think you're just trying to buy yourself time. That's what I was going to ask. Why does he need the 2 weeks? I don't know. Like, is he going to like go through it and look for things to like be like, this needs to be redacted, or?
Maybe, I don't know. Look, there are certain things that you would never argue don't need to be displayed. So for example, if there was a message from someone who's relevant to the case and it contains their birth date, their phone number, their social security number, no one needs that. Like that would be proper to redact out. But what's happening here is the prosecution has been trying to keep all of this hidden from the public. And, that's kind of, we're talking about the comments about, normally light is the best disinfectant for these kinds of, especially cases like this that are obviously of a high profile nature, substantial public interest. A lot of people think these are frivolous charges, that they're retaliatory, that they're this, they're that. And it's ironic that in essentially a First Amendment case and a prosecution of a journalist who, brought to light all the stuff about Karen Reed, and look what's happened in Karen's case. They're dropping like flies. The cops are getting in trouble. They're getting reassigned. Like light was shined on that case by our client, as it turns out. And in his own case, the prosecution is not allowing any light to be shined and depriving him of the opportunity of showing the public what's going on and depriving the public the opportunity to explore for themselves. And there's something ironic about it, but it's also frightening. It's 2025. You would think Massachusetts would be the kind of place that's kind of sophisticated with this kind of stuff and very open-minded. But when it comes to public access in court files, it feels more like a very darker place from a darker time.
Okay. Is Massachusetts the only state that has things like worded differently, done differently, or is it different in every state?
I don't know. Look, where I come from and where anything I've ever heard anyone else, the word you would use is something is under seal. In federal court, something is under seal. In New York State court, something's under seal or not. And you get unsealing orders in this. I had never heard the legal term of art impoundment until I started, getting involved in these cases in Massachusetts. But whether other states use it or not, I don't know. It's not so much the terminology that's concerning. It's the ease with which lawyers are able to just say, this is under impoundment and we're going to impound this. And everyone's just like, okay. If you try to do that in New York, there's a specific statute that says it can only be sealed in these circumstances, and the court has to find that it's met, and there's a hearing and you determine it, and it just doesn't go on and on and on where everything is presumptively impounded if everybody feels like it. It's very different.
Okay. Another question. He said, if you want it today, I'll allow it without prejudice. Hell does that mean?
Well, it just without prejudice just means I'll let you renew any argument. I mean, he basically says if you want the discovery today, you can have it. I'll impound it, but without prejudice means you can argue that I'm going to unimpound it, which is essentially what we did. When something is granted without prejudice, that means you can revisit it.
Oh, okay. Okay.
In other words, the judge is saying, look, if you want the documents, you can have them today. I'm going to temporarily impound them, but I'm going to hear you about unimpounding them in the near future. That's all that means, which is what we did.
Why do you think, like, just like, what is it just him by himself, Mr. Cosgrove? Because it feels like, why did homie need all these more weeks for his 10 outstanding discoveries? Like, they're outstanding.
Well, at present time, there are officially two prosecutors handling the case. Mr. Cosgrove and Ken Mello is officially, one of the prosecutors. We are, as you know, attempting to have him removed because we think he's a defense witness for a lot of reasons that have been said before. But as it stands right now, he is officially considered one of the prosecutors. I've never seen him in person ever. So he has not been to a court appearance in, I think, over a year. I think he's been to a couple on Zoom. He has not signed any pleadings or filings or anything in this case since I've been here, which is over a year at this point. So we're dealing with it. But, for now, there are two prosecutors officially.
Okay. Next question. Proctor, you stated that Proctor and a civilian witness have messages that are impounded, right?
Right.
And you were like, why would they want them impounded? For privacy when he's on a press tour. Okay.
Right.
Is that separate from or included in the 5,000 to 6,000 pages of stuff of discovery?
That's a different issue. So the Proctor and civilian witness that we're talking about specifically refer to messages that were included in our motion to dismiss of several months ago. But because all of this was impounded, we could not, we had to redact out those messages. So we want to unimpound those. We want to unimpound all the other messages from the police, prosecutors, civilians, and the stuff that we just got last week. Again, what you're calling the 5,000 pages, there are many, many messages in there, which also ought to be unimpounded and probably should be. And, you heard reference in court to what some of those are, who they come from. They're very relevant to the case. They're very relevant to people who instigated the case, who may not be police officers, and their motives and what they were doing. And again, in due course, I imagine all of this will be aired out for the public to see, whether it's at a trial or pretrial motions, discovery demands, whatever it's going to be. But I mean, this stuff can't be hidden forever. It does feel that they are just trying to kick the can down the road to prevent information from getting out, which may not put them in a light that's favorable for them. It may reveal some things that they don't want revealed. And, it may confirm some other allegations that we've been making for quite some time. We'll have to wait and see.
Okay. And you stated that that's more of a reason for them to be available.
Absolutely.
I thought that was great. I was like,
yeah, no, you more, the public is entitled to more, not less information. Again, that's the parties who want to see what's going on. I mean, the public is not a party to a lawsuit or a criminal case, but they have a right to know. The media has a right to know. The public, civilians have a right to know. The taxpayers of the county have a right to know. I would think, like, today more than any other day. Why are they going after this guy? Why are we paying two special prosecutors doing this? I mean, this is coming one day after it was just announced that they paid a special prosecutor, over $565,000 for the Karen Reed fiasco, when they had able-bodied prosecutors right there next to them. And, you find out that it's like a third of their allotment or their budget, and they're, ignoring other things that could have required attention because they went all in on this. Well, it's the same issue with what's going on. You know, the taxpayers right now are paying 2 special prosecutors on Aiden's cases. You know, they're not in the Norfolk DA's office either. I mean, it's a little different because in our case, they're claiming there's a conflict. So they had to get a special prosecutor, where Brennan, there was no conflict because Lally and McLaughlin were still there. But the question is, why are we spending that money to go after him, given what this is? How much is it costing? What are we getting for it? I mean, the public is entitled to these kinds of information.
So didn't they take Mr. Cosgrove out of retirement?
I believe so. He was a Superior Court judge for a period of time. He was a former prosecutor in the office years ago. And I believe that Mr. Cosgrove was in retirement when he was tapped for this. I believe that's true.
Is that normal?
No.
Like not even like nothing about this is normal, right? Like absolutely nothing
about this is normal. And in my life, I have never seen a DA's office implement special prosecutors the way that they do in this county. I mean, I've seen it obviously with Aiden's situation. I've seen it to some extent with Karen Reed. I've seen it in even the lower district courts. This person can't be we need a special for this. And it's really indicative of a larger problem. I mean, why does this keep happening? Why is this necessary? And, you know, if you want to go down the rabbit hole and say, if the district attorney recognized that they have a conflict of interest in going after Aiden, which I believe is proper and appropriate, but, you know, their remedy is like lipstick on a pig, because the real conflict are the Massachusetts State Police. Okay. What led them to go after Aiden? His reporting on the Massachusetts State Police and the DA's office, in his mind, alleged corruption in the Karen Reed case. Okay. He called Michael Proctor corrupt, right? He believes that other state troopers are corrupt. Well, who are the very people who went after him and arrested him? These people, the people that he's criticizing. These are the people that searched his phones looking for things. I mean, can you see the conflict here with the state police and their own bias? Look at the civilians that the state police, or civilian as it were, who the state police used to assist them and relied upon in this investigation. It just happens to be, you know, the one civilian who hates Aiden more than anyone else on the planet. I mean, is that a red flag? It ought to be. And, you know, there'll be more to talk about that perhaps in the next week or so. But there are so many conflicts and problems with all of this, and they just keep going. And when your response to all of these issues and concerns, and these are matters of public concern, is to impound everything, that's not how you do it. That's not how public trials and cases are supposed to be handled.
So you've never experienced anything like this in your life. What about any of your like any former colleagues or anything? Any like other people you're close with in New York? Like when they hear about this, are they like,
no? I mean, again, the closest comparison that I could ever find to what goes on in Norfolk County is what used to be the case in the Brooklyn, New York DA's office. They had some problems with some bad eggs, some bad cases, some bad detectives who worked with them. You know, a guy named Louis Scarcella, you know, you look him up. He's famous as a detective who many convictions were reversed because of him and some of the prosecutors he worked with. But what's going, not to the extent it's going on in Norfolk, what's going on there, I mean, every big case they touch feels like it's on the verge of collapsing due to police misconduct, mismanagement. incompetence. I mean, obviously, Karen Reed is just a fiasco of fiascos. You saw what they did with Sandra Birchmore, which was just horrifying. If they had their way, it would have been just a suicide of a girl nobody cared about, and that would be that. What's for dinner? That's how they looked at it. Federal government had a very different view. They look at it as a murder of a federal witness, and it's a death penalty eligible case. You see what's going on with Aiden. This case is just being mismanaged in many ways with the conflicts and everything else. And you even see it now happening in this Brian Walsh case, which, I mean, there's real legal issues with whether these famous Google searches that he made, which are not really in dispute in the sense that he made them and they're real. And, again, putting aside the presumption of innocence and the law and all that, he is entitled to the presumption of innocence. He is entitled to be convicted on admissible evidence only and all that. But just as a matter of, what happened or what didn't happen, he clearly made those searches. They are as incriminating gets. Mm-hmm. And because of the conduct of the state police, they're in jeopardy of losing that. Now, what does that mean for the rest of the case? I don't know. And it's the same cast of characters in the state police from the Norfolk office that they finally have started to fumigate, as you can see. I mean, there's in the last week, 3, 4, 5, however many of them have been moved on, and there's rumors about other ones. But I've never seen just a constant problem with the DA's office and the cops. It's a Massachusetts thing where they embed these detective units in the DA's office, which is a terrible thing to do. The prosecutors on a certain level have to wear their big boy pants and supervise the detectives in an investigation. And if there is misconduct, they're the ones that are going to be obligated to handle it, disclose it. But when you have an office that is run like a fraternity house between the detectives, and you saw it from the text messages in Karen's case, and you see how close and friendly they are with the prosecutors, you see how there's also an improper relationship in the way they all kick up money to the DA's coffers, which that should never happen. I mean, that's actually illegal in New York, under the conflict of interest rules and whatnot. And this got Charles Hines in trouble in Brooklyn. There was a federal investigation of the Brooklyn DA years ago. It didn't go anywhere, but they the Eastern District of New York put a lot of work into it. And one of the things they looked at were these improper donations of people who worked in the office. And when you see in that office, a lot of the prosecutors, they're kicking money up to the boss. A lot of the state troopers, they're kicking money up to the boss. And that sounds more akin to a crime family than a prosecutor's office. Now, it's not a lot of money. It's not making or breaking Morrissey, but it's symbolic. I mean, you're beholden. They're public servants. They're not making that much money. They shouldn't be having to kick up to the boss. It's a sign of loyalty. And, so you wonder when you say, well, why could Proctor and these guys get away with this stuff? Why would nobody find out, or why would nobody challenge them? Might it be because they treat the office like a fraternity house, and they have their groups? So all this stuff seems to happen in Massachusetts, but not other civilized places.
Civilized being the operative word. All right, a couple more, and that's it. Okay. It's easy. I asked you this, and you answered it before. I asked if all the charges were connected, which I don't know how many times I've heard this, but how'd you explain it to me?
There are 3 separate cases that
yes
have nothing to do with another. I mean, the reality is they treat the client like, he's Moby Dick, and they are going to, go after him with a harpoon, no matter what, to try to get the great white whale, and they'll throw anything they can at him. So, there was the one indictment which relates to all the names you've heard from the Karen Reed cases, who were allegedly intimidated because, he said some things that they didn't like. expressing a viewpoint on a criminal case, which, as we all know, was acquitted, and that led to charges. Then there's a case involving his former girlfriend who received a grand jury subpoena when there was no grand jury proceeding, which is outrageous.
Not girlfriend. I've heard.
Right. I'll let all you know what I mean.
FSP, former slam pig, but not girlfriend is what I've heard.
I'm not gonna call her that, but
no. That's just what I've heard on the streets. I've just heard that on the streets. I'm not
former. For our purposes, we'll just call her girlfriend, even though I'll take the heat that goes with that. He was lured over there. It's been publicized previously. We'll talk about this at a later date, that there's powerful evidence of a setup that we've discussed previously that might have led to that. Then you have a third charge, the pizza shop thing that we spoke about. And there was a fourth one that, resulted in an acquittal a few weeks ago about a restraining order violation when, the ex-girlfriend showed up at court for the first time knowing that he'd be there, and showed up with Paul O'Keefe and, that other civilian we talked about earlier, who seems to have a very strong role in getting Aiden, who hates him more than anyone, had her fingerprints all over that one as well. So they just keep going and going and going, and they're always attempting to revoke bail, seek bail. All they're doing is making them stronger, and all they're doing is creating more attention for him. And at the same time that they're trying to suppress all the information from the public. And, we're not going to tolerate that. And I don't think the public is either. I think they want to know what's going on. Why is he being charged with these? What's the evidence and what led them to do this? And, there might be some surprises when people learn.
I just feel like it's so intricate. I feel like they won't stop at anything. I don't know what it's been about, like this week and last week, but all of a sudden it seems like everything's clicking now. And I'm like, oh, this is why they did that. And because before it was just kind of like a bunch of different shitty stories that somehow meshed together. And I've heard people be like, well, there's the Karen Reed case. And then they're like, well, then there's the Turtleboy case, which is a spinoff. And I don't think that's true, because I think this is just a deeper level of the Karen Reed case. Like, this is just the seedier underbelly of what happened in the Karen Reed case.
Again, they don't like his viewpoint. He had an audience. A lot of the public agrees with him. There was a whole movement, if you will, what they call Free Karen Reed movement, whatever.
Never heard of that.
Never heard of it. That grew from him reporting on this, and they don't like it. And so what do? People complained, and they came after him. And we're talking about all the attempts they've made to get him. They also tried to indict him and Karen together. And they tried to indict them right before Karen's first trial. Okay. Now, if you want to talk about underhanded move, that clearly was designed, there's no question, to revoke her bail and have her standing trial focused on, I'm in jail and it's hopeless. And is that going to, does that coerce a plea? It's kind of a mind fuck, obviously, if you're in jail. And obviously, if she had been indicted, it would have been in the news. And right before jury selection, she's indicted again. That's what they wanted to do. And, the grand jury in that case, which was presented by Mello, they declined to indict either one of them, even though they didn't testify in their own behalf. And, you've heard the old cliche that, a grand jury will indict a ham sandwich if you ask. And that statement actually originated with a former judge of the New York Court of Appeals, Saul Walker. I think sometime in the 1980s, he made that famous comment, and just laughing at how arcane and silly the whole grand jury system is, at least, in certain places. And in that situation, they asked the grand jury to indict. It was a one-sided presentation, no defense, as you know, no cross-examination. and they refused. And that's really the first red flag or a check on what these people have been doing. I mean, it's virtually unheard of for a grand jury not to indict when a prosecutor asks like that. So that was kind of a major tell as well.
Is there any part of you that's like waiting for some, like, just like you feel like you have to be on your toes because you never know what they're going to throw at you, or what kind of, like, because it seems like they take.
Yes.
Okay. Okay.
No, I mean, when you drive by, whether it's in Canton or you go into the courthouse, you got to cover your heart, cover your heart, Indy. I mean, listen, the game is played very differently there. Now I think, that's changing a little bit. It's still very culturally different for me, the way they do adjournments and how things work. I'm still learning and feeling my way through the process of how they do it. But it does feel like, though, there has been a change somewhat. Our arguments, I think, are being more accepted, and I think a lot of them are being borne out. I mean, Karen was acquitted. That's a big deal. Okay,
it's huge.
Reporting on this and running around saying, "I think she's innocent, and I think you people are corrupt, and I think you people might have done this and that," and whether you agree or not with his manner of doing it. In a general sense, she's acquitted of all these charges. That helps him. It does. It definitely does. The fact that Michael Proctor was terminated in disgrace supports what he said about him. Okay. The fact that Proctor's supervisor was just removed from the unit, and, they can call it whatever they want. That's a demotion. Let's not kid ourselves. Okay. He may keep his rank, but you don't go from homicide detective to, staring at a desktop at headquarters doing nothing. That's a demotion. Other state troopers have been, sanctioned as a result of this. Other things are still potentially going to happen. There does appear to be some degree of vindication here, but we still have to deal with, at least for now, what amounts to 3 separate criminal trials. So this feels like it's going to go on for a long time, unless somebody decides enough is enough and pulls the plug. But, we've seen nothing to suggest, at least at this point, that that's going to happen.
I feel like there's something irritating about people who are like, well, I don't agree with like his methods. Well, it's like, dude, if you don't agree with it, then you're just going to keep putting up with the corruption of your state. So what do you want? You want like, you know what I'm saying? It's just kind of like irritating. All right. 2 more questions and then we're done. Then you have to look.
Okay.
1, but you answered it, but just for the people, is it always going to be Dooley?
Not
love
necessarily.
him.
No, I mean, obviously, he's got a nice manner to him, and he's very calm on the bench. He's a very calming presence. He's got a incredible sense of humor. The judges can vary. It depends. I mean, at this point, Judge Doolin's had a lot of involvement in the case. He handled the motion to dismiss. He's handling all these discovery issues. So he does have a lot of involvement. But no, it doesn't necessarily literally have to be. Realistically, I think there's just one judge in Norfolk County that would never preside over our case. I think that's understood by all involved.
All right. Yeah, I thought he was great. Did he kind of remind me of Gary Busey a little bit? He's just like he's like a funny character. I thought he was cool. And last question. This is a good one to wrap it up on. What should we expect coming up? Like August 13th? Anything prior to that? Should people be like on the lookout for things? Is there anything like, are there good? Do we see good in the future? Do you have a positive feeling about this?
Well, I think ultimately, yeah. I mean, why wouldn't you feel positive?
I do too.
I think this is an overreach, and you can't go after people because they have a certain viewpoint that differs from your own, even if they're a little more aggressive than other people in how they present it. I mean, you've got to be even-handed. You can't let people just call the police whenever they feel like it and say, this is upsetting, so make arrests. You can't do that. There has to be limits. And again, it's kind of at a crisis level in Massachusetts. I mean, you've had national news over people getting arrested for throwing, little tiny rubber ducks on the street and getting arrested by the state police, getting arrested by the Canton police, executing 5 search warrants, filling out 50-page reports. Again, the resource allocation is insane. So I think we feel good. As far as what's going to happen next, I would assume something will happen before August 13th. Without getting into the weeds too much, we are not at all satisfied with the production that we got last week. And I think it would be in everyone's interest to address that as soon as you can before August 13th, so that, we can keep the ball moving and not just kick the can down the road. So, hopefully we can flesh out those issues prior to August 13th.
All right. Well, thank you. So hold on. Thank you so much.
Mr. Bederow.
It was good having you. I appreciate it. We made
Nice.
it just under an hour. Thank you for coming on. You're always welcome here. And can you, just for the sake of the people that watch the morning show, you saw the Bederow, Upsetero, Spaghettero stream.
Yeah, I did. Someone told me, I thought it was hilarious. We listened to it at home as we were just kind of getting ready to, go to work and do stuff, and it got a good chuckle around the house. It was fun.
I didn't want to tell him. If you ever came on, I wanted to be like, all right, guys, let's have him tell you.
It's funny. We liked it.
All right, good. Will you be here August 13th?
I will not be in person on August 13th.
Okay.
I will be at an undisclosed location, but I will be on the Zoom appearance, and I would imagine have a lot to say about some of the issues that relate to discovery and how it's being handled, impoundment, and where it goes from there. But no, so that'll be half a suit day, if you know what I mean. Yeah.
And then Daffy ducking it from the
exactly. Flip flops down low, right.
But
I will not be there in person for that one.
All
and
right,
that's pre-scheduled.
I'm gonna try and be there, and if you're on the Zoom, I'm gonna be in the back. I'll be like,
for you. Go. I mean, I think people,
I loved it.
It's an interesting case, and I think it's important that people see what's happening, and particularly where the issues are the First Amendment and not releasing public information. I mean, this is kind of scary stuff. This is the kind of stuff where if there's precedent set in this way, where you can go after journalists because they upset you. Again, a journalist who brought to light the scandals of Karen Reed, which all played out actually in that way. I mean, you can see what's happening. This is not the kind of thing that you'd think we'd be doing in America 2023, 24, and 25, as opposed to the way they used to do things in, Mao's China and Stalin's Soviet Union. I mean, it's just not how we do it. If there are people that are upset about, what is being said about them, there are remedies. If they have the courage to seek remedies, there are remedies. But the answer is not just, call the cops and throw everyone in jail. That's not how America works. That's not the answer to everything. Is I don't like what they're saying about me, so just lock them up and put them in jail. That's not what we do.
Such a waste of resources.
Mm-hmm.
Such a waste. All right, go watch the Sox game.
Okay. All right. Nice talking to you.
Thank you so much, Mr. Bederow. God bless. Doing the Lord's work. Everyone say goodbye. Say goodbye to our favorite guy.
Mr. Bederow.
Thank you, John. All right.
See ya. All right, guys. Thank you for sticking through that. My apologies if my questions were things you already knew the answers to. I just had absolutely no idea about a lot of that. And I just like to be sure. I like to ask 10,000 questions to make sure that I completely know what the right answer is. I don't want to be feeling dumb if someone comes up to me and they try to talk to me about something and I don't know my ass from my elbow. Okay. I want to make sure that I know these things. I feel like it's important. I feel like this is important, especially if I'm going to be going. I want to make sure I know what's up. All right. Listen, thank you guys. Thank you all. We got some gifted memberships. Welcome to the club. Thank you, Not That Dina. Thank you, Mimi K. Thank you, Shannon Loves Connecticut. Appreciate it. Mimi K sends $10 to the school to have the roof fixed and says, our teacher is being taught. I love class 103. I mean 202. This is 203, Mimi. This is 203, but that's okay. This is why you're in summer school. This is why you're in summer school. If you're new here, guys, we have summer school every morning, give or take an hour or 3. We never know. We don't know what time we start. It's summer school. We just kind of wing it. Thank you guys for coming and hanging out. I appreciate it. Let me see if I missed anything. No, I don't think so. All right, perfect. I hope everyone behaved because I'm going to go back on the replay. Okay. And I don't look at the comments when anyone's on, but if I go back on the replay and I look at these comments and anyone embarrassed me or acted up, you will be hearing about it on Monday. I'm going to put your name on the board and I'm going to call your parents. I don't care if they're dead. I'm calling them. Okay? Thanks. Have a wonderful day. God bless. Have a good weekend. Relax, chill out. Take some time to yourself. Get out there, garden, breathe, touch grass. God bless. See you guys later.
This portion has been sponsored by Jury Tamps. Jury Tamps, fit for any key cycle.